2019-452, State of Arkansas versus Aaron Tullis. With this case, there are 3 revocation cases: 2019-55, 2018-287, and 2017-460. We also have Marion County case 2019-142. Apparently that's a newly filed case. And wasn't there a revocation in Marion County as well?
There is, Your Honor. I say that, I know that if it's not filed, I know it's coming because I had seen it.
Yeah, we talked about the one yesterday.
I can't believe you'd have failed to mention something.
So we're going to take up all of those matters at this time. 2019-452 is for arraignment this case on charges of possession of controlled substance, Class C felony, possession of controlled substance, Class A misdemeanor. Well, actually, he entered a plea of not guilty in front of Judge Putman on January 9th on the charges in the 2019-452. In this case, Judge Putman did arraign him, and then he was instructed to appear here today to get on my scheduling order. So what we don't need to do the arraignment. He's on the scheduling order. In 2019-452 for a trial during the week of May 18th and for a pre-trial on May 14th. Mr. Cooper, you've been appointed in all of these cases.
We have been, Your Honor.
You had a revocation first appearance in these cases, these 3 revocation cases in Baxter County, in front of Judge Putman, and entered a plea of not true. It appears. And then they were set down today for hearing. I take it we're not thinking of a hearing today, but rather just to get it scheduled.
Your Honor, we've been asked that it be set also for February the 6th.
You know, the state, I'm sorry.
Go ahead.
You know, the state had made an offer to resolve these cases, and the state withdraws that offer. We'll proceed to deal with this revocation on the 6th, and the other cases when that's completed, Your Honor.
Right. We need it down for February 6th on all 3. That's 2019-55, 2018-287, and 2017-460. Now, let's quickly move over to Marion County case. Marion County case 2019-142 for arraignment. We've already arraigned him on this. He was arraigned last October on it. The matter is on the schedule for jury trial in Baxter County during the week of January 27th. This is on the Marion County case.
Marion County.
Oh, James represents him in Marion County. Well, we think, we've texted James to see if he's even applied in Marion County, Judge.
Let me see what he said.
Yeah, you guys put in your, you put in,
No, they have
defender's
listed,
office, put in Mark. Amy?
Sarah Schmutzler
She's
is
applied.
the attorney.
Oh, Tara. Oh, there you go.
Well, just because she's new in the office and representing him, the court is going to continue that case out to the week of the 24th, is what I'm remembering.
That is correct, Your Honor.
I'm gonna set it over to continue it to the week of February 24th as an excluded period. And then put it down to reappear in Marion County on February 19th, which is, I think, the next time I'm there. So that takes care of all the cases that are currently on the docket with Mr. Tullis. It's recognized by everybody there's a new revocation petition been filed in Marion County. Mr. Tullis, your situation is this. You have the new charges in Baxter County, which we have set for trial in May. You have Mr. Cooper's been appointed as your attorney. There are 3 revocation cases in Baxter County where you're down for hearing on those on February 6th. In Marion County, you have one case that was already set for trial during the week of January 27th, but there's been a transition of counsel in public defenders in Marion County, and Tara Schmutzler has been assigned to your case. I anticipate that she'll be in touch with you promptly. I'm moving your trial that was set for January 27th in Marion County to the week of February 24th as an excluded period in order to get Ms. Schmutzler up to date on your case and in communication with you. And then we'll have a reappearance in Marion County on February 19th. So that's where you stand at this time, sir.
You all right? The computer froze and I missed almost all of that from, I don't know, did we talk about a bond? Because I'm on a $20,000 bond. I was wondering if I can get released back out onto my bond or get a bond.
No, we have no bonds based on its revocation holds.
That's
Unless Mr. Hicks feels different.
the $20,000. I'm showing a $10,000 bond in Marion County. But basically, you're on a revocation. You're arrested on these revocation petitions, and all of those are no. There's 1 in Marion coming up in Marion County, and 3 in Baxter County, and all of those are no bond holds. And given the fact that the case was as old as it was in Marion County, and we're having to move it off for another month, the court at this point is not going to grant a bond.
How am I being revocated in Marion County? I've never been on probation or parole in Marion County.
Well, we'll check that. I believe we looked it up yesterday, and you were on probation. But there's not been a petition. Mr. Etheridge seems to remember he's seen a petition. But if there's nothing of record being done at this point. We're taking no action on a revocation in Marion County. I'm just advising you that I was informed there was one. So it may well be, you're correct, that we're not doing that. We are doing it in Baxter County, however, and that's set for hearing on February 6th.
So I'm not allowed to try and seek other counsel and bond out to seek other counsel to fight these charges in the world.
You are allowed to seek, always allowed to seek other counsel. My understanding is you have applied for the Public Defender's Office, and the Public Defender's Office has been appointed to you.
I know, but what if I want to seek other counsel? That's why I was wanting to bond out to see what kind of other options I could get. I mean, I might be facing a little.
You are entitled to communicate in any way you can, use assistance of friends or family or whatever, and make whatever arrangements for counsel you want to. The court won't interfere with that in any way. But I'm not just going to let you out of jail so you can go on either committing crimes or.
I don't do that. I'm still involved with Care Center. I go to Care Center Church every week. I'm involved with Ty Cotter. I mean, I'm sober. I've been clean. I mean, I'm not out there doing nothing stupid. I'm trying to get my life back. That's what I want to do.
If that gets proven at trial, I'll be the most delighted person in the world, Mr. Collis. All I'm going on, formal charges have been filed on you, and that's what we're processing.
You got put on the page.
I just don't understand why I can't, get a chance to go out there and get some stuff straight. Get back into the ministry or do something.
Well, talk to Mr. Cooper about it, and.
I did talk to him yesterday.
Huh?
I talked to him yesterday about it.
All right. So,
Pled guilty November 14th.
if you want an argument presented to the court, I'll be glad to listen. But you do that through your attorney. Okay? You may be excused. Next case we'll take up is 2020-4. State of Arkansas versus Casey Lawson. Mr. Lawson, you're down for arraignment today on this charge. Have you made any arrangements to be represented by an attorney?
He's not applied to us, Your Honor.
Mr. Lawson, did you hear what I said? Mr. Lawson, are you intentionally not responding, or did you not hear something I said?
Let me text the jailer.
We can hear you, sir.
All right. So it's not applied. Mr. Lawson, the question I'm asking you is, do you have an attorney representing you? You have a constitutional right to an attorney. What I'm advising you of that means is you have the right to go out and hire the attorney of your choice. If you, and the courts don't get involved in any aspect of that. That's your choice of who you hire, and the court will not interfere with that. Your case is for arraignment today. I'd like you to at least have initiated the process of arranging for an attorney, and that's why I'm asking the question. Do you have an attorney representing you? All right.
What's an attorney?
You have the option, if you discover that you cannot afford to hire an attorney, you still have the constitutional right to an attorney, and what that means is that you have the right to have an attorney appointed for you. The way you obtain, you notify the court that you want appointed counsel, and you obtain an appointed counsel, is you fill out an application for the public defender's office. Those applications are there at the jail. You're going to have to ask the jailer to provide you an application. It's not going to happen unless you take some action. So if you want an attorney, you either have to hire an attorney or you have to make application for the public defender's office. And that's simply going to require you to take some action. If you choose not to take any action, so be it. At this time, Mr. Lawson, I'm advising you that you're charged with domestic battery. It's in the second degree. It's a Class C felony. On those charges, how do you now plead?
Watson, yeah.
I don't understand anything. Please.
Did you say you don't understand?
Yeah, I don't understand what it means that you're trying to say to me.
I'm asking you to enter a plea. What that means, you either enter a plea in light of your, the uncertainty of your response, and in light of the fact that you haven't consulted an attorney, or you don't even have an attorney at this point, the court is going to enter a plea of not guilty on your behalf and put you down enter a scheduling order setting up this case on my trial schedule, which is assigned to. The scheduling order will be entered that will set your case for trial the week of May 18th, and it will also set you down for a reappearance on May 14th. In addition to that, I'm going to put it down, I'm going to add to the scheduling order I want you in front of the court on February 6th. We'll take this up and try to move, I've got to move this docket along today, but we'll take up your situation on February 6th. You may be excused at this time. Court calls 2020-8, State of Arkansas versus Kelsey Giltner. There's also a case, a revocation case, 2017-148, involving the same defendant, Kelsey Giltner. Ms. Giltner, can you hear the court all right?
Yes, sir.
All right. I have you down for arraignment today on charges of possession of controlled substance, Schedule 1 or 2, that's a Class C felony, possession of controlled substance, Schedule 3, that's a Class A misdemeanor, possession of drug paraphernalia, that's a Class D felony, theft by receiving, Class A misdemeanor, no liability insurance, fictitious tax. I see Mr. Cooper, I believe we've already appointed the public defender in your case. Are you appointed in both cases?
We are, Your Honor.
All right. Ms. Giltner, on the charges that 2020-8 that I read off, how is the defendant now plead?
She pleads not guilty, Your Honor.
And in that case, we'll set this down by scheduling order for trial during the week of May 18th and a reappearance on May 14th.
May.
May 18th and May 14th, that's correct. That's when the
There's no.
when the case is set for trial. Now, in the revocation case, which is 2017-148,
He was talking about trial, right? That's not my next reappearance.
I'll address that issue for you in a minute. Let's take care of one thing at a time.
It's not fair, you didn't know
In
that.
case 2017-148, where you were subject to probation, there's a petition to revoke your suspended sentence, which was filed on January 7th of 2020. It primarily lists as your violations, the basis of this revocation are the new charges that we just arraigned you on in case 2020-8. All right, Ms. Gilder, the court is proceeding on 2017-148. You appeared before Judge Putman. He set this down because it's a case I put you on probation on. It comes to me. And I'm looking at here, and you have not been formally arraigned on this charge as yet, so on the allegations contained in the petition, which are the new charges that we've already arraigned you on in 2020-8, the court will advise you that, or request of you to enter a plea. How's the defendant now plead on a revocation?
Your Honor, she enters a plea of not true. We have not visited about her new charge or the revocation. In talking with Mr. Etheridge, I believe that on the revocations, we're not asking anything to be set for next week, given the volume of the docket. If we could have her reappear, Your Honor, for hearing or resolution on February, is it the 6th that you were here, Judge?
Yes, February 6th. I'll put it down for hearing on February 6th.
Your Honor, on the...
And I'll note for the record that somebody had already put it in as for her to reappear on the next week on the 23rd. So by setting it on February 6th, I am removing that part of the order, so it should appear on the next day.
So we'll have to back February 6th.
So that'll be February 6th. Hopefully by that date, she will have visited with her attorney, and there are other dates between other dates to have this matter, either of these matters set on or set down on, we'll take them up. But I'm now scheduling the hearing on the revocation on February 6th, and the trial of the new charges is set for that week of May 18th. Ms. Giltner, I heard you expressing some concern about how far out in the future that trial date was, but that is to give you and your attorney time to talk and discuss the case and decide how you want to proceed in this case. And if you want a sooner hearing date to resolve some issue, to take up a hearing on something, you need to discuss it with your attorney and then request it to the court, and we'll reschedule. But that's the trial date out in the future for your new charges. All right?
Yes, sir.
All right, you may be excused.